Lots of times I'll have a client that comes to me because they get injured on the work site or in the course of their employment. There are a couple of things to look at. The general rule is this: if you get hurt in the course of your employment, you cannot sue your employer. You're limited to receiving workers' compensation benefits, which means insurance benefits that will pay for your wages and for your medical bills. However, if there is a third party, if there is some other entity besides you, besides your employer, that was negligent, that caused your injuries, then the answer is yes. You can have a successful case for injuries resulting from negligence that occurs during the course of your employment, as long as it is somebody that caused the accident besides your employer. So that can be the circumstance of a motor vehicle accident. You could be a tow truck driver, for example, that has an accident with another vehicle. You obviously cannot sue the employer, but you can sue the driver and owner of the other vehicle. Most scenarios are when you're a construction worker and you're on a job site, and you might work for a carpenter or a subcontractor because of a failure to provide safety devices. You cannot sue your employer. However, the laws in New York State allow you to bring a claim under the labor laws against the owner of the property and against the construction manager or the GC, the general contractor on the property. So there's an initial analysis that we'll do to figure out who are the parties in charge, what was going on, who was responsible, and who failed to act properly.